It asks itself, what is the message that people send to others when they wave the old flag at public gatherings? That is the question. And there's no doubt that what their conduct signifies, not the flag, their conduct, what their conduct signifies is that they celebrate and yearn for the days of apartheid. That is what that conduct signifies. It's unambiguous. Oh, for the good old days of apartheid, when black people were treated as second-class citizens. It expresses a nostalgia for the good old days of apartheid. That is what it does. And it is utterly demeaning of black people to say, oh, for the days when only white people were recognized as first-class citizens and black people were relegated to an inferior role of second-class citizens. That is what the message is by anybody who displays that white flag gratuitously, not for the 101 other legitimate reasons, but gratuitously waves that flag at a rally. And certainly, let me do it now. Let me do it immediately. Because we address public displays simply because on the facts of this case, this was a case of public display, and it seems to us that it ought to be uncontroversial that the public display of the old flag constitutes hate speech. And that is why we confined our submissions to public displays of the flag, only because the facts of this case concern the public display of the flag.
What about the order number 2?
That is quite correct. The court did not limit its order in that way. Our learned friend argued then and justifies today why private displays should similarly constitute hate speech. And we accepted that is so. We can't imagine that it can be suggested that, as the examples he mentioned, where a one-on-one racial insult should not constitute hate speech. After all, it constitutes crimen injuria. If the common law should prohibit it, why would the act designed to protect against exactly that kind of demeaning conduct, why would the act not also control that conduct? So we submit with respect to our learned friends that is the proper interpretation. There might be fine lines to be drawn in the private domain. I can imagine if a group of racists want to get together and put on white hoods and talk to one another in racist terms, then it might be different. But in any circumstances where the flag is used, where the flag is communicated to other people who do not form part of your meeting or your consensus, that would constitute hate speech even though it occurs in private. So our emphasis on public displays must not be understood to suggest that we contend that a display in private does not constitute hate speech. It merely means that we confine ourselves to the facts of this case, and for that reason didn't address it. So I'm not. I think, yes. 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 Yes, and then one. I submit with respect that that would be the sensible understanding, and for that reason the appropriate understanding, because one can imagine that it becomes very different when your let me say this. What that might mean is simply that hate speech becomes hate speech only if it's communicated to an outsider. But whether that communication occurs in the workplace or in the home or in a private school should not make any difference. And remember, Kwelani was a case about the public dissemination of hate speech. So Kwelani was not a case which concerned the question where the lines of privacy might obscure the lines of hate speech. And let me just emphasize here that, as I've said, what constitutes hate speech by the gratuitous display of the flag is the conduct and not the flag. And for that reason, we submit that the qualification, which is also appropriate, is that the court excluded from the prohibition any conduct of the kind described in the proviso to Section 12. And I've little doubt that that is an appropriate exclusion. But what my learned friend then does is to say, but look, there are other circumstances which would not fall within the proviso, but where the display of the flag would nonetheless be innocuous and not hate speech. And for that reason, we would submit that to cater for the gaps within the proviso of Section 12, that it is better to make the prohibition subject to a proviso which excludes functional displays of the flag. In other words, or to limit the prohibition to gratuitous displays of the flag, where there's no other functional purpose to it. Then anybody who says, but I had another legitimate reason to display the flag, history or demonstration or whatever, all those examples my learned friend mentioned, those are not gratuitous displays of the flag. Those are occasions on my learned friend Mr. Mpofu's son's book, where the flag is used for a functional purpose. Even if the cover of the book does not fall under the proviso, it would still be excluded. It doesn't constitute hate speech because the flag is used for some other purpose. It might, if you're confident that you can draw a clearer line, but which is equally wide. I submit with respect that the language in the proviso is also open to debate. And gratuitous simply means without function. So it shouldn't be too difficult, and what it does is to conceptually capture what the exclusion should be. And that is to say, if you have a purpose in doing it, then you may do it. But if you don't have another legitimate purpose, and you merely wave the flag in public, then that is when you send a racist message. No. No. Well, no, that is so. Let me just say that it would be perfectly legitimate and appropriate for you to say this is a case about public display, and I address the implications of public display. You will then have to deal with the fact that the High Court order doesn't qualify display. It simply speaks of display. But if you were to say that display must be understood for purposes of this case to be public display, whilst leaving private display for another day, that would be a perfectly legitimate and reasonable, appropriate response to this case. My learned friend speaks of other symbols like the stem and the Springbok rugby emblem. Now, may I just use them to illustrate precisely why it is a false analogy, and it doesn't address the right question, and that's this. Of course, the stem and the Springbok emblem share some similarities in their history with the flag. That is so, and that's why he mentions them. But no reasonable person would say today that there is any comparison between those three symbols. The fact of the matter is that, particularly when democracy dawned, under the leadership of President Mandela, the establishment embraced the stem and embraced the Springbok emblem. I can remember the president at a rally in PE wearing a Springbok cap. The establishment embraced those symbols and used them in the project of reconciliation. And rightly or wrongly, I'm not commenting on the virtue of it, but the fact of the matter is that that is where those two symbols took a different turn, and why they are today embraced by a lot of people. I'm not saying that they're uncontroversial, but they are embraced by a lot of people. And no reasonable court would say today that the message they send, the message sent by Siya Kolisi when he leads the Springbok World Cup winning side onto the field, are a symbol of apartheid South Africa. That would be absurd. Those two symbols today bear a completely different meaning. And the vague similarity in track record and origin is of no consequence at all. I beg your pardon?
Isn't the short point that it doesn't meet the test?
No, not at all. It doesn't begin to move the test. And simply, yeah. And let me conclude this part of the topic before I get to the procedural points. Just to refer you for sentiment rather than direct comparison to the Constitutional Court judgment in the Pretoria street names case. That is Tshwane City v. AfriForum, 2016, Volume 6, SA 279, Constitutional Court, where the court also spoke of symbols of a different kind, i.e. street names. And the subject matter was not hate speech. I'm not suggesting there's a direct analogy between the two cases. But what the Chief Justice did speak about is how important it was in our democratic South Africa to recognize that symbols means different things to different people and that we should accommodate one another. And I commend particularly paragraphs 6 and 8 and 15 and 16. And if I may just read two or three sentences from paragraph 15. It is impermissible to ever adopt an attitude that seems to suggest that some of our people can afford to endure the pain and torture induced and symbolized by instruments of the colonial and apartheid legacy, probably because they have endured them long enough to find them tolerable, if not acceptable. Nothing that objectively encourages or seeks to perpetuate the stereotypes, prejudice, or discriminatory practices of the past is to be tolerated. Inclusive unity in diversity, recognition of the culture and history of white and black South Africans, and reconciliation are our chosen paths to the prosperous future. Now, if this case is to be judged in the context of that sentiment, then there can be no doubt that waving the old flag at a public occasion is a message of hate that we cannot tolerate. Can I turn lastly to the procedural issues? The Equality Act, the first argument is that the orders were not within the jurisdiction or competence of the Equality Act. The powers of the Equality Act are set out in Section 21. Now, our learned friend's first point is the Equality Act can only act if there was an incident, a complaint of hate speech. Well, there was, and there was a complaint of hate speech. The flag was waved at the rally. So the entry point is satisfied in that there was an actual incident, not a theory, an actual incident, and there was a complaint about that incident, and the court found that that incident constituted hate speech. Its remedial powers, given that it had the power to be seized of the case, its remedial powers are then defined in Section 21. It says the court must firstly determine whether the hate speech has taken place. That's 21.1. In this case, that is what it did. It inquired and it determined that hate speech has taken place. The remedial powers are then set out in 21.2. After holding an inquiry, the court may make an appropriate order in the circumstances, including a declaratory order. So the remedial powers aren't confined to orders relating to the particular incident. The remedial powers are open-ended, an appropriate order in the circumstances of the case, which may include a declaratory order. And what's more, if you want to understand better what that appropriate order might be, also bear in mind that in the previous section, Section 20, the Act confers the wide standing to litigants as in the same terms as the Constitution does. In other words, it makes it clear that people like the Foundation or the Human Rights Commission can come to court in the public interest. So that it then seems blindingly obvious that where there is an incident and there is, of which a complaint of hate speech arises, and there is reason to think that that kind of incident will happen again and again and again, and there is a dispute about the lawfulness of the incident, it's very clear that there is the list that Nell said was not even necessary for a declaratory order. But there is actually a list. What is the appropriate, let me pick up the words, what is the appropriate order? The appropriate order is to say, that incident constituted hate speech, and as for the future, we don't today want to fine people or punish them, but let me bring clarity to the law today. Let me resolve the dispute by giving notice to the world that waving the old flag on public occasions constitutes hate speech. We submit with respect that a declaratory order was eminently appropriate, and certainly the appropriate order in those circumstances. A declaratory order, after all, my learned friend has some suggestion that it is an abstract order, but it's not abstract at all. The declaratory order is one of the most important judicial tools for the determination of actual disputes or even possible disputes. The declaratory order is recognized as a judicial remedy in Section 38 of the Constitution and in Section 21(1)(c) of the Superior Courts Act, and then, as I say, in the Equality Act, in Section 21(2)(b). And Justice Schippers made the point that ex parte nil judgment of this court made it clear that the court was competent to grant a declaratory order, even when there was no live dispute. The question whether there is a live dispute is a relevant question in deciding to exercise the court's power to grant a declaratory order. But now, and the jurisprudence since then have recognized that there are occasions when it is appropriate to grant a declaratory order to clarify the law, even when there is no live dispute. And may I just, in that regard, on the development since Ex parte Nel, there's a very useful judgment of the full bench of the Gauteng Court, North Gauteng Court, which traced the law of the jurisprudence of this court on declaratory orders. In the case of Minister of Finance v. Oak Bay, in 2018, Volume 3 SA 515, paragraphs 51 to 62. But we don't, for purposes of our case today, we don't even need to debate those subtleties, because there was an actual event, an actual transgression, and there was an actual dispute. So any sincere civil rights organization would urge you to resolve the ambiguity in the law and not attempt to defeat your attempt to do so. We submit that it is eminently suitable and appropriate that you should resolve the uncertainty about the lawfulness of displaying, gratuitously displaying the old flag at public events. Those are our submissions.
Thank you. What do you say about the proposition that I put to Mr. Katobi that regards the different, I don't know if you're noticing the heads of argument to ask for the violation of Section 10.
Yeah. I was hoping you wouldn't ask me the other question. Now, with respect, with deference to the High Court, the Equality Act caters for various species of wrongful discrimination. The most common form of wrongful discrimination is treating people in different ways based on a prohibited ground. Another species of discrimination is to demean people by hate speech on prohibited grounds. But there are different species of the same genus, and we submit that it's appropriate to identify the particular species of transgression and to deal with the case as such. And in this case, the appropriate species is hate speech, even though it might arguably also form some other form of unfair discrimination.
Because I suppose in the criminal context, if the matter would be referred to EPP, the accused in that case is saying undue spitting, or more correctly, a duplication of conviction.
Yeah, no.
From the same conduct.
Yeah, no,
I don't know if one can say that. You cannot really say that in the case here of a statutory wrong.
yeah. Yeah, one would also suggest that although we're not in the domain of criminal law, these are statutory wrongs, but the same reason why we don't permit a multiplicity of convictions for the same conduct, the same principle would probably also guide us in the application of the law on civil wrongs. People shouldn't suffer two civil convictions for the same conduct. Thank you.
Yes, Justin, I intend on being as concise as possible and deal with some of the submissions of my learned friends. Firstly, I'd like to address the alteration of facts that appears from my learned friend for the Nelson Mandela Foundation. The case brought by the Mandela Foundation was very clear. AfriForum is cited because there is a disagreement about whether future displays of the flag ought to be permitted. It was never their case that AfriForum were waving flags. If that was their case, they would have brought that case. They would have said on this occasion, AfriForum members were there holding the flag, and we want to hold AfriForum accountable for that. If that's what the facts, that's the case they would have brought. It's not the case they brought. Today, my learned friend intimates AfriForum waved this flag. It's done for theatre. It's not a fair representation of the facts. It's very obvious from the papers that that's not the case. And it's unfair to intimate that now.
But isn't the point simply this, Mr. Oppenheimer, Mr. Premier has admitted, that there was a dispute. Somebody waved the flag. And when you look at the broad standing provisions in Section 20, could either the Nelson Mandela Convention or the Human Rights Commission has approached the Equality Court of the Character?
Yes, they could have. No, here's the difficulty. The difficulty is, of course, to say someone waved a flag, I'm not going to cite them, I'm going to cite you because you think there's a free speech right. There's a problem with that. In other words, ordinarily when we think one makes a complaint, one complains against the person performing the conduct. That's a list between those parties.
Yes, but on the facts of this case, as I understand Mr. Katobi's argument, is that there was, in fact, part of the factual matrix was this debate, and AfriForum said, well, as far as we can see, this is expression. And Nelson Mandela Foundation took the content of view and said it was not speech. And that is why we come to the Equality Court. And it's why it's powerful, given the fact that given statutory power to grant a declaratory order as to whether or not conduct constitutes hate speech, what is the problem?
So one of the questions might be this. Imagine that there are two rivaling academics who take a view about whether a particular symbol ought to be banned. Could they approach the Equality Court and say, the two of us disagree about whether the symbol should be banned, we'd like you to pronounce on it? Now, I would think in that situation,
The Commission, Mr. Oppenheimer, doesn't exist as a private entity. It's a constitutionally established institution. It serves the public interest. Why could it not approach the court? Even though it was not, strictly speaking, party to what had happened at the display. If somebody, for example, makes a report to the Human Rights Commission and say, I've been offended by this display, is the Human Rights Commission not entitled to approach the Equality Court for a declaratory order?
yes, they can. And so they can act.
So what are we talking about?
Well, let me explain it. In such an instance, what will happen is that someone will go to the Human Rights Commission and they'll say, Party X violated my rights. The Human Rights Commission can then either lay a complaint in its own name or on behalf of that person. And they won't do it in the abstract. They will summon that person to court and they'll say, you performed this action. We submit that that's an act of hate speech. So I'm not questioning the locus of the Human Rights Commission. Of course they have the right to bring cases, but they bring them in relation to particular incidents and they bring them against the party that performed the incident.
But Mr. Oppenheimer, assuming that the song that you complained about, the deliverable song, is sung in the right of the political party, and the political party is known, right? And you feel that it's harmful, but you can't identify the individual responsible for the group that sang the song. Can AfriForum come to the court?
Well, there's a distinction in that case. So in other words, there what happens is that AfriForum brings a case against the EFF. It says your members were singing this song and brings a case against the EFF. That is not the Mandela Foundation's case. The Mandela Foundation does not say AfriForum members waving this flag and that's why we're citing you. They don't bring a case like that.
But if the flag is displayed at a function, similarly if the song is sung in rally for the political party that you know, and the flag is displayed in a function that is organized by AfriForum whom we know. So why would AfriForum be entitled to approach the Equality Court without identifying individuals who sang the song? But you're saying that in this case,
Well, the difference is, the question is there an organisation that represents those unidentified members? And so, in the two AfriForum cases that have been brought, the one which has been decided by Judge Lamont, claim is brought against the ANC as a party because it was sung at an ANC rally, and it was sung, and it was secondly against Mr. Malema, who had been singing it on many occasions. So the parties were identified. The disanalogy here is that you don't have an AfriForum event with AfriForum members singing a song. What you have is, and this is not contested on the papers, Black Monday is spontaneous protests across the country about farm matters. AfriForum participates in those protests, as do many other organisations. Some of those participants, and no one makes the claim that any of those people are AfriForum members, that AfriForum condones it, or is associated with it, or anything to do with them. Some of those members display the flag. Now, it is not the Mandela Foundation's case that they get to cite AfriForum because there's a link in those members. That's not the case they brought. The reason why they cite AfriForum is they say, we have a disagreement about the law. And that's why we're citing, and we want to flesh out that disagreement in court. That's why they cite AfriForum. I beg your pardon, Justice? It explicitly doesn't endorse the displaying of that flag. The papers are very clear. AfriForum says, we have no love for the flag. If one of our members waves this flag, we're going to tell them to put it away. And that's their general approach for all of their rallies. In other words, they specifically don't endorse the waving of the flag. Mr. Ngatobi implied that the opposite is said, but that's not at all what's in those papers. In other words, AfriForum's account itself explains what its position is about the flag. It explains that AfriForum takes the view that the flag ought to be consigned to the dustbin of history. And Mr. Ngatobi takes the view, see, AfriForum are endorsing the waving of the flag. I just cannot reconcile these two positions. I mean, I don't know what more AfriForum could do to say they don't like the flag, they have distaste for the flag, but free speech matters, and that there is a danger when you start to ban things, and there will be second-order effects. That's the position that's very clear. Now, a couple of related points. The one is, it's been suggested by Malona Friend for the Minister that there is no ban. Mr. Trengo, of course, speaks very comfortably about this being a prohibition, because it is, of course, a prohibition. What is a prohibition? What is a ban? It's when you're prohibited from doing something. It's when there will be consequences for doing it. The question is simply, is it a widespread ban? Is it a total ban? Well, it's not a total ban because there are some examples in the proviso when one can use it. In those examples, you're not banned from doing it. In the other cases, you are banned from doing it, and there will be consequences. You can be hauled before an equality court, you can be fined, you can be investigated by the DPP. That implies a ban. In other words, if there are sanctions that follow from your conduct and you're not free to do it, there's a prohibition, there is a ban. It's not a total ban. I think all the parties, AfriForum makes it clear that it is not a total ban, but thinks that having a ban in the first place is a problem. Now, my own friend for the Human Rights Commission does have a suggestion that I think maybe deserves more consideration, which is that he accepts that I've given a number of examples of displays that fall outside of the proviso, but are not gratuitous, and would be hit by the current prohibition. And in order to deal with that, says, well, those innocuous cases, those cases where it's not a racist display, those cases where it's not an endorsement of apartheid, those cases must be given protection. And the language used there, I think it's page 5 of one of the friend's heads of argument, paragraph 10. He says, our case is also confined to gratuitous public displays of the flag. A display is gratuitous if it does not serve any lawful purpose other than to celebrate our apartheid past. We accept that the old flag may be used for a variety of purposes which do not convey a racist message. Accordingly, we confine our submissions to gratuitous public displays of the flag, that is, public displays that do not serve any other purpose than to celebrate and express nostalgia for the days of apartheid. In other words, it's to limit a particular category of cases. Justice, you'd asked me earlier, are there examples where one can say this is hate speech? And this might be one of those cases, in other words, where it is very clear the particular display is a full-throated endorsement of apartheid. when it is clear that the displays are saying, we yearn for apartheid to be brought back, and we think it's a celebration of racial superiority. That's going to meet the threshold. Now, there are going to be all these other examples I give where it doesn't meet the threshold. One of the examples is Sizwe Mpofu Welsh's book, The New Apartheid, where an image of the flag, of the old South African flag, is used to denounce the current regime, to say this is still apartheid continuing. This is apartheid privatized, is the tagline of the book.
Would that not be under artistic kind of expressions that are under the proviso, writing a book?
Well, the question is, so this is the difficulty.
Obviously, I'm not saying it is.
Yes.
But I'm saying that's a good example to demonstrate what you're trying to say.
I would think not. There's a difficulty in that route. So our learned friends also say, well, when we look at the military parade, let's just say it's theatrical and therefore it's art. What you might have, is if we start to make those moves, is that the case that we say, well, you've got the protesters and they're saying bring back apartheid, and they're then some before the court, they'll say, well, that's performance art. This is a performance piece, it's theatrical. We're protected, we fall under the proviso. What will happen is that all those categories will then be subsumed. So one way to deal with the problem is to say, well, a gratuitous display is one which meets the threshold. In other words, this court could declare any display of the flag which amounts to the propagation of hatred, the incitement of harm, or is harmful speech itself, is hate speech, is a violation of Section 10 of the Act. That would be in terms of the law. In other words, it just targets those displays that are actually violations. And it admits that there will be displays that are innocuous, that that can't be squeezed into a proviso, that don't meet one of those other threshold examples. The example cases that I've given, there's another famous case of a black woman who arrived at a party which was described as no taboos in 2017 in the media. And she wore a dress that was made out of the old South African flag. Now, it's not clear that that fits into any of the proviso examples. It's not a work of art. She's wearing the flag. It's not journalism. It's not reporting on anything. It's not academic. But it's also clearly not done to promote any hatred or to harm anyone. What she's doing, one could assume, is to say she's saying the flag is a taboo. And she's showing disdain for the flag. So those sorts of cases you want to be able to cater for. What we have at the moment is the blanket ban. So in other words, the assumption that all displays that can't be put into one of those proviso categories is necessarily hate speech. And one way to cure that problem is, as my learned friend suggests, is to limit it to this category of gratuitous. And one way to reach gratuitous is to say all of those cases that actually meet the threshold test. And then you can avoid all these examples that I've given. And then what will happen is that someone will come to court, someone who waves the flag, and then the question will be, well, have you done it in a way that is gratuitous? And the court can then determine it on the facts of those cases. But it can send the signal that the court wants to send, which is to say, there are clearly cases to our minds which we think are going to count as gratuitous. Here's what the threshold test is. If you meet that in your display, if you do all the things that Section 10 tells you can't do, then you have a prohibited display of the flag. And that can provide proper guidance without overstepping what the statute provides. That might be, within the powers of this court, might be a wise way of dealing with the issue. A few small things to correct as well. My learned friend just made mention of Mr. Ritz and said he acted in contempt of the order. He doesn't mention that the judge who presided over that case, Judge Lamont, dismissed their case. They sought leave to appeal to the Constitutional Court. The Constitutional Court refused to hear them. In other words, to claim that what Mr. Ritz did was contempt of court is improper. The court found otherwise and dismissed their case. But it also shows something else, which is that what they intended on doing in that matter was to have criminal liability for someone who was not a party to the case. The argument they made, and it's evidence in the judgment itself, which is cited in their heads of argument, is that all South Africans are aware of this court order, all South Africans can be held in contempt for a mere display, and the sanction that was sought by Mr. Ngatobi in court was 6 months imprisonment. This is why we are talking about bans, why we're talking about prohibitions. In other words, there will be consequences, and they're not just moral consequences, they're not just expressions of disdain, it means jail time. That's what it was sought. Now, the court dismissed that relief. But this is something to be borne in mind. In other words, the Equality Act Court itself has strong powers. It can refer one to prosecution. It can hand out damages claims and fines. So because there are consequences to the display, this court must be very careful in how it crafts its judgment. It must constrain it to those cases that actually do breach the Act. And that can be determined going forward on a case-by-case basis. But the true clarity is to say gratuitous displays are equivalent to propagation of hatred, the inciting of harm, and harmful speech itself. And that would be in accordance with the Act. And that avoids all of the litany of examples that I've given. I have no further submissions.
Not the rest of them. What did you say?
Pura. Amajaji azoba busy la asebenza ngaphandle.
Thank you very much.
Yeah, that battery is okay. It wasn't charging. It charges and it stops. Yeah, that one.
Check it out. Thanks.
A viewing.
got a guest. Masih
He's just packing away.
Because I'm already now. It's just